Hello everyone, welcome to CoreSteno Daily Dictations. Today's dictation is based on income tax judgment. Dictation speed will be about 80 words per minute. So let's begin. Get ready. 3, 2, 1, start. These appeals filed by the Revenue under Section 260A of the Income Tax Act 1961 relate to different assessment years from 2018 to 19 up to 2022 to 23. It is stated that these appeals involve identical questions of law, however, they diverge on facts. The appeal in ITA 424 pertains to assessment year 2021 to 22, wherein the assessee filed its return of income on 22/12/2021, declaring total income and claiming refund of TDS amounting to exemption treatment and offering income to tax under Section 115A of the Act para. The assessing officer passed a draft assessment order proposing additions to the income of the assessee on account of payments received with respect to seconded employees in India and receipts from professional services. The assessing officer bifurcated the amounts under different heads, first being reimbursement of costs relating to seconded employees and second being receipts from India-based clients for services performed in and from the United States of America para. It was observed that certain receipts amounting to professional services were examined and a portion was held not falling under the exemption clause under Article 12(5)(e) of the India-USA Double Taxation Avoidance Agreement. The total receipts were accordingly brought to tax as fees for technical services under the said treaty provisions. The assessee filed objections before the dispute resolution panel against the draft assessment order. The dispute resolution panel, by order dated 10/8/2023, rejected the contentions raised by the assessee and upheld the additions made by the assessing officer. Consequently, the final assessment order was passed in accordance with the directions issued by the panel para. The Income Tax Appellate Tribunal thereafter allowed the appeal filed by the assessee and set aside the assessment order. The primary issue arising for consideration is whether payments received on account of secondment of employees constitute taxable income as fees for technical services under Article 12 of the Double Taxation Avoidance Agreement and whether receipts for services rendered in and from the United States fall within the exemption provided under Article 12(5)(e) of the said agreement. The challenge in ITA 423 relates to assessment year 2019 to 20, wherein the tribunal held that a sum representing cost to cost reimbursement on account of secondment of employees is taxable as fees for technical services under Section 9 bracket 1 bracket 7 of the Income Tax Act 1961 as well as under Article 12 of the Double Taxation Avoidance Agreement. Stop.